Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Normally, whenever we appoint the drivers for my car, or suppose if I am a logistics owner, you have got a fleet of buses or trucks, normally the drivers will be going, we will employing somebody. Then what we will see is we will check up whether he has got a driving license or not. Before that, we will send him for the test drive. Normally, in my case, I will sit with the driver and I will take him to about 4 to 5 kilometers. In the meanwhile, I will ask him to stop in the midst of the road. I will ask him to stop aside the road. I will ask him to apply sudden brakes. Then we will understand whether he is a professional driver or not. Normally, owners will do this type of tests and they will check up. Better to be careful, they will ask whether you have got a license. So if he shows the license, we will check up whether it is in running condition or not. That is the expiry date, that's all. We don't want to see whether this is a genuine license, whether it is a fake license, whether it is obtained from India. We don't bother. Same thing happened in the case and Supreme Court also agreed for it. So this is an MV Act compensation case. Two judges bench, Justice Hemant Gupta and Vikram Nath of the Honorable Supreme Court of India, while deciding the case of Rishi Singh versus New India Assurance Company Limited 2022 in Civil Appeal number 4919 by 2022 dated 26th July 2022. The Supreme Court bench clearly held that owner is expected to verify the driving skills of the driver but not the genuinity or the correctness of the DL before the appointment of the driver. Owner is expected, right? So, no doubt, so when once something is proved to be false, entire thing will be proved to be false. That is English concept. Falses in falses in omnibus. It is not applicable in India, right? So, here, if you go to the facts of the case, here the appellant Rishi Singh is the owner of some trucks. So he appointed the driver after verifying his driving skills. Right? The vehicle met with an accident on 27/4/2015. The appellant stated that he employed the driver by taking the driving test, in which the driver drove to the satisfaction of the employer. And he has checked up regarding the driving license. He produced the driving license issued in Nagaland state. It is also in India, Nagaland. And it is valid up to for the more 3 years. This man worked with him for 3 years. Right? So, when this man asked for the DL, the driver produced the driving license issued by the RTO of Nagaland state. No doubt. He believed them. So after the accident, what happened is, normally the other party claimed and this man asked the driver to give his license. Yes, the details of the license, other things were produced before the court. Ultimately, the driving license was found to be fake. So therefore, as the driving license is fake, the insurance company, the High Court, till the High Court, it was held that, the High Court held that the insurance company is entitled to recover the amount from the owner. That is pay and recover policy. You know, in the last class, in the last semester, that is law of torts, I told you, pay and recover the policy. So he doesn't want to actually give back the amount to the insurance company. Therefore, he has filed an appeal before the Supreme Court. So please remember, Supreme Court has placed reliance on a celebrated case. That case is United India Insurance Company, right? United India Insurance Company versus Lochen, L-O-C-H-A-N, Lochen and others, 2003. So 3 judges bench. So they sat on the topic and they said that once the driving test is taken by the employer, it is sufficient precaution. It is a sufficient precaution for giving him employment. But it is not the duty of the owner to check up whether it's a fake license or whether correct license or not. In the meantime, in the 3 years period, so many MEIs might have checked the vehicle, might have checked the driver license. What they did done? What have they done? They also did not verify whether it's a fraud. So because of the insurance company, since they have to shell down some money, they have asked their investigators, or they have sent the so-called driving license to the Nagaland, and only the truth came out. Otherwise, this driver would have continued for 10 more years, or till the expiry of the driving license. So ultimately, the Supreme Court, please remember, held that owner need not verify the genuineness of the driving license. Of course, that does not mean to say that insurance company has to pay. Insurance company has got the liberty to recover the amount. But here, Supreme Court in its wisdom stated that since there is no fault on the owner of the vehicle, so insurance company have to pay. So now the burden of proof is left to the insurance company. So anyway, very good judgment in favor of the prosecution. But if you are an advocate representing the new insurance company, definitely you will not agree. Of course, since it is a Supreme Court judgment, you have to agree. But normally what we think is, have we pay the insurance amount to a person who is not having a valid driving license? This question will come. But anyway, Supreme Court has decided, as long as you are the owner, the main point, as long as the owner, yes, you are supposed to check up his driving skills. You are supposed to check up whether he has got valid DL or not. Whether it is valid or not, normally nobody is bothered. So this is the main problem. Luckily, the judgment came in favor of the owner. But friends, remember, in 90% of the cases, definitely the insurance company will collect the money from the owner if the driver is not a genuine driver, if the driving license is not genuine. Anyway, good judgment. Please read it and enhance your legal knowledge. Thank you very much.